Now, staying with issues of virtual court proceedings, here's some international perspective from Dr. AYODELE AKENROYE, a board member and immigration judge with the Immigration and Refugee Board of Canada. In the last 9 to 10 weeks, he's presided over remote hearings from the comfort of his home. He shares with us his experiences and some global best practices.
COVID-19 has made us to realize how outdated our justice system is. It equally provides limitless possibilities for us to leverage technology to improve access to justice in meaningful ways. Using technology to resolve dispute is not a new thing. In fact, as far back as 1999, technology has been used to resolve dispute online. Online merchants, particularly or notoriously eBay, paper, at the point resolved 60 million disputes annually. Over 80% of these disputes were resolved using software alone and do not require intervention of third-party notarials. While the formal justice system globally has been slow to embrace technology in resolving dispute, Estonia, a very tiny Nordic country of about 1.328 million, as far back as 2006, implemented online court system where most disputes are resolved completely on 100% online, and they are fully automated their court processes and electronic communication tools. Their online court system has been used in criminal proceedings, civil and administrative proceedings, among other areas of law. As recent as 2016, the province of British Columbia in Canada established Canada's first online tribunal dedicated to resolving disputes involving motor vehicle injuries, small claims up to $5,000, condominium landlord and tenancy issues. All of this demonstrates that there are limitless possibilities for Nigeria to incorporate technology in delivering justice, and is actually moving in the right direction in modelizing an outdated justice system. However, we need to exercise caution and know that the information and communication technology infrastructure we have in Nigeria is not yet fully developed, or is not even developed if you have to compare ourselves to other countries. And Nigeria cannot compare ourselves to advanced countries with robust and highly developed information and communication technology. If Nigerian justice system wants to fully embrace digitalization of their court system, they have to know that being a digital society means exposure to cyber threats, and they need to be making solid investment in cybersecurity infrastructure as well. If we want the digitalization process to work in the Nigerian justice system, then we have to be very cautious and methodical in the implementation. Speed cannot be the only focus. Yes, COVID-19 is putting pressure on all stakeholders and clients once their case resolved speedily, but we're in a largely untested waters regarding the digitalization of court proceedings in Nigeria. Yes, the idea of e-filing has been mooted and advanced in the past, but it didn't gain much traction. So what are the considerations for judges? In my own opinion, each head of court at both the state and federal and state level should determine how best to integrate technology into their court in light of their local realities. In other words, a one-cap-fit-all approach should not be used and will simply not work. Each state chief judge and lawyers in that state should decide whether to bring every judge or courts online at once or on a rolling basis, gathering feedbacks and observation to improve the process from the people, from the users. So are the users. Chief judges should carefully consider which case types of proceeding, including pretrial matters, are most appropriate for virtual hearings. Again, all case types or proceeding may be heard virtually, but there will be particular challenges for each one of them in light of local realities and resources, and this should be carefully calibrated and implemented. And I also actually think, and I too believe, that head of courts in Nigeria and lawyers should be realistic about their current technical infrastructure to determine readiness to support a transition to remote hearing. So because Lagos is doing it, because Ogun is doing it, because Abuja, Borno, Kwara, does not mean all CJN, all chief judges rather should roll out, should adopt remote hearing as a practical way of resolving matters. So if in terms of practical matters regarding remote hearings, as a judge should consider whether there will be any prejudice to one or both parties from the case, proceeding by video or teleconference. And if there's a limited prejudice, or the prejudice is outweighed by public interest in having the case had more expeditiously, then the court should order the matter to proceed by video or telephone.